the afternoon session. I'm Dan Jaffe, and I'm a professor here at Case Law School, where I teach both legal skills and education law. And our topic for the afternoon is Curriculum Under Command, Federal Authority and the First Amendment in Higher Education. So it's my privilege to introduce our four panelists today. And bear with me, I will say they're four distinguished panelists because they all have very impressive resumes. So, and they each asked me to embellish on their resume as well. So bear with me for a moment. I'll introduce them all, and then they can come up in turn. Our first panelist is Robert Shibley, and he will talk about higher education's political reckoning and how colleges enabled Washington's power grab. He is special counsel for campus advocacy at the Foundation for Individual Rights and Expression, also known as FIRE. He has more than 2 decades of experience in FIRE's efforts to defend liberty at America's colleges and universities. He was the organization's executive director from 2015 to 2022. He spent some time in private practice as well, where he represented students and faculty in private litigation, tenure, and disciplinary matters. At FIRE, Shibley led the organization's expansion beyond campus and its development of litigation and legislative advocacy, including efforts related to the 2020 Title IX regulations. He conceived of and helped launch FIRE's Stand Up for Speech litigation program, which ultimately achieved 13 victories against campus speech codes in 15 federal cases. He is also the author of Twisting Title IX, and his commentary has appeared in the Wall Street Journal, the USA Today, the Washington Post, Time, and other outlets. He has also commented on NPR, CNN, Fox News, and other national media, and one of 2 on our panel, 2-time graduates of Duke University. Our second panelist is our own Atiba Ellis, and he will talk about the efforts of the federal government to transform educational policy, that they represent a thinly coded censorship of critical race theory as an academic literature and as a proxy for attacking race-conscious discourse within higher education generally. Professor Ellis is the Laura B. Chisholm Distinguished Research Scholar and Associate Dean for Enrichment and Engagement, in addition to being a professor at Case Western Law School. A nationally noted voting rights scholar, his primary research focuses on how racial and class-based oppression interact and continue to abridge and deny the right to vote to communities on the margins of American democracy. His work has analyzed voter identification laws for their socioeconomic effects, situated felon disenfranchisement laws as enforcing a political underclass, and has analyzed the scope of the Citizen United decision as well. Another 2-time graduate of Duke University. Our third panelist, Samuel Bagenstos, am I saying it right? Bagenstos. Samuel Bagenstos. He will talk about funding termination as a sanction for Title VI enforcement. He's the Frank Millard Professor of Law at University of Michigan Law School, and the Arlene Susan Cohn Professor of Social Policy at the University of Michigan Gerald Ford School of Public Policy. He recently returned to Michigan after a 4-year leave serving in the federal government, where he was special counsel to the Department of Health and Human Services. He also served as has also served as general counsel to the Office of Management and Budget. Additionally, he has been an appointee at the U.S. Department of Justice, where he served as Principal Deputy Assistant Attorney General for Civil Rights, the number 2 official in the Civil Rights Division. He has published articles in journals such as the Yale Law Journal, Stanford Law Review, Columbia Law Review, California Law Review, Virginia Law Review, the Cornell Law Review, and the Georgetown Law Journal, and many others. 2 books on law, one called Contradictions of the Disability Rights Movement, and another, Disability Rights Law Cases and Materials, and has written articles for non-academic audiences as well. He has argued in front of the Supreme Court 4 times, and additionally argued multiple times in the Michigan Supreme Court and federal courts of appeals. And our 4th speaker tonight is Dr. Christopher Thomas. He will speak on A Tale of 2 Emails, looking at institutional decision-making in the current political environment. He's an associate professor of educational leadership and policy at the University of Florida College of Education and an affiliate faculty member with the University of Florida Levin College of Law. He has a PhD in educational studies, specializing in educational policy, and a JD from the Ohio State University. He, in his prior iteration, he worked for the law firm of Frost Brown Todd LLP, where, like yours truly, he represented school boards. Let's see, judicial extern for Chief Judge Guy Cole, the U.S. Court of Appeals for the 6th Circuit. His research focuses on the intersection of education law, policy, and practice, with special attention to issues of democratic governance and participation. He also podcasts. So, like I said, a very distinguished panel. Without further ado, let's start with Robert Shibley.
It's the right arrow.
All right, cool, thank you. Well, thank you for having me, and thank you, Law Review and Maggie and everybody for arranging this. It's the title of my slideshow is probably going to be more exciting than the content of the slideshow. Partly because I have been rewriting it a little bit as we went through this morning, and I don't want to belabor things too long, but what I basically have is an outline of the things that have gone on, and you're going to hear a lot more about, the details of how those have gone on. But I'm going to provide sort of a basic outline of a bunch of the things that have happened. Frankly, so many things have happened, I probably will miss some. But then one thing I do want to talk about in a little more depth is the what FIRE has come to call the cumulative theory of Title VI harassment that has been going around through now 2 administrations. So, okay, so federal pressure on colleges post-October 7th. That's Columbia there, and basically this came, in my opinion anyway, in sort of 3 overlapping and sort of indistinct, but nevertheless, distinguishable waves. The first one being the Inquisition phase, and the symbol of that is the congressional hearings, particularly the one from December 2023, having to do with protests and anti-Semitism on college campuses where they had Ivy League presidents there. The second one, regulation, and this is where I'm going to spend sort of the meat of my time talking about what's going on with Title VI, which is the older and sort of original progenitor to Title IX, which is what what Fire and I particularly have spent a lot of time in the past decades dealing with, and then inundation, because I wanted to end in Shun for the third time. I felt like that would be good, and that's as good a description as any of all of the things that have been happening since probably around March of this year under the Trump 47 administration. Okay, so let's remember what happened in the Inquisition wave. October 7th, 2023 were the attacks on Israel, and Israel, I went back and looked at by about a week later they were striking Gaza in pretty in a pretty big fashion. So by the 16th, we were already seeing pro-Palestinian protests hit a lot of the major universities, and the ones that really stuck out the whole time, the one that stuck out the most was Columbia University. I think part of that is because of the nature of Columbia as a place that is congenial to protest sort of traditionally, or maybe if not congenial to protest, at least one where it's a tradition to do that. But I don't think we should overlook also that it happens to be in Manhattan, and you can easily get there if you want to cover it for the news. But Harvard and Penn also had big protests, but so did places like UNC and Indiana University. I don't know what it was like here at Case, but I can tell you that Indiana was kind of an interesting one, and I won't get too far into this, but Indiana is actually so Fire, for those of you who don't know, defends free speech. We were founded to defend free speech on college and university campuses back in 1999, but in 2022 or 3, we expanded our mission to start defending speech off campus as well. But we still do all of our campus work, and one of the things that we are known for is these campus free speech rankings. And one of the schools that tanked the most this year was the University of Indiana, or Indiana University, and we think the reason for that is, we do the polls and we poll statistically significant numbers of students each place, but a lot of them commented on this because we have an open response place, and one of them is Indiana hired snipers to oversee some of the protests. They actually had snipers on the roof of a couple of buildings, and believe it or not, that does make an impression when people are standing up there with a rifle over you, which we said was ridiculous at the time, and I think Indiana University's general counsel is no longer our friend, I think is probably safe to say. They're not really our BFFs anymore. So a lot of things, it was very intense, and you all probably remember that, but it's easy to lose sight of how intense it was at the time. By December 5th, the House Committee on the Education and the Workforce had assembled this now sort of famous or infamous anti-Semitism hearing with the presidents of Harvard, the University of Pennsylvania, and MIT. And you probably more or less remember how this went. So that was, December 5th. By December 11th, the president of Penn had resigned. These hearings did not go well. And by January 2nd, sort of after pressure from the hearing, but also allegations about plagiarism, Harvard's president, Claudine Gay, had also resigned, and she became the Harvard president with the shortest tenure in history. Now, what went so wrong at these hearings? There's a lot of different ways you can look at this, but one of the ones I want to look at quickly is that the questioning itself, if you go back and read it, you can see a level of sort of skepticism and hostility from the congressional representatives that you don't usually see when dealing, or you hadn't previously seen when dealing with Ivy League presidents. Representative Wilson asked President Gay, I want to know what is the percentage of conservative professors at Harvard? Ms. Gay said, I do not have that statistic. We do not collect that data. Harvard itself doesn't, but the Harvard Crimson actually does that every year. In 22, they went through and they looked at the professors and they found 37% said they were very liberal, 45% liberal, 16% moderate, 1.5% conservative, and 0 very conservative. And I don't mean 0%, I mean literally 0 people, right? And so just to give a comparison of how that compares to the same year overall average citizens of the United States, 37% of Americans said they were moderate, 36% conservative, 25% liberal, 9% very conservative, and 7% very liberal. So as that kind of knowledge has become more and more, it's filtered through, we've started to see politicians be more and more skeptical about claims that universities are making meaningful efforts in terms of having intellectual diversity. Let's see. Representative Grothman went after President Gay at Harvard, also having to do with the students' voting record. Again, obviously you're far to the left, etc. And also, most famously, Representative Stefanik went on kind of a tear about what Harvard would allow to be said on its campus, and President Gay was saying, "Well, we value everything. We tolerate all kinds of expression." What did she say? We embrace a commitment to free expression. But as I was sharing with folks at dinner last night, we had just a couple of years before had a fight with Harvard at Fire over their demand to a student to take down a flag that they were hanging, they had hanging in their dorm room that was Nicki Minaj in a bikini saluting in front of the American flag. And you wouldn't believe the level of resistance Harvard put up against us about having this flag up. So again, the reason I bring this up is not to to some extent to pick at Harvard, because I enjoy doing that, but also because I think it's summed up well. I talked to during this whole mess, I talked to a journalist who said he was interviewing on different things, and one of the things he asked, who are the constituencies, there, and he said a top Democratic senator had said that Hamas has a bigger constituency in this country than Colombia does right now, and that kind of sums up what it was looking like from the political perspective. So that was the Inquisition. Okay, regulation. So in November 2023, OCR, which is the Department of Education's Office for Civil Rights, started launching these Title VI anti-Semitism and Islamophobia investigations. They launched originally with Columbia, Cornell, Wellesley, Cooper Union, Penn, and Lafayette College, which is in Pennsylvania. And by March of 2024, this had risen to at least 46. And we started to see the results of those in June of 2024. So this is, the waning days of the Biden administration. So what we learned from that was this. So the definition of hostile environment, discriminatory harassment in the educational context, so far as it can be determined, comes from a case called Davis versus Monroe County Board of Education from 1999. It's a Supreme Court case. It was written, it's a 5-4 case written by O'Connor and joined by the court's 4 liberals. And they repeat this standard 3 times. They say hostile environment is, and I've paraphrased it here a little bit, but you can look it up. I encourage you to take a look. Hostile environment has to be targeted against somebody. It has to be discriminatory, so it can't just be based on a hostile environment to be discriminatory harassment actually has to be discriminatory. It can't just be hostile because they don't like you personally. It has to be so severe, pervasive, and objectively offensive that it effectively prevents the victim from getting their education. Now, what we saw in June of 2024 was this in the title. So that was a Title IX case, right? In the Title VI context, which is a parallel statute. Title VI, like I said, is sort of it's the statute from which Title IX was derived, and the courts have been explicit that you can apply the principles from one to the other when it makes sense to do so. They said that for Title VI, which does since about 2004, which all parties sort of have agreed to decide that it covers anti-Semitism and Islamophobia along with race, color, and national origin, which is what is actually written in the text of the law. OCR, they said that what Lafayette and other colleges had failed to do was assess whether the incidents individually or cumulatively created a hostile environment for students, faculty, or staff. Now, this is where it gets kind of in the weeds. So I'm going to give you sort of an example. And this is what happened with Lafayette that really triggered a lot of concern at Fire, and I think should concern people here because of the way it impinges on protected speech. So here's one of the examples that OCR gave. And it said this is at Lafayette College. At an October 25th, 2023 rally, a pro-Palestinian student held up a poster saying, "From the river to the sea." Okay? And you all are probably familiar, it's a very controversial statement. People have, differing opinions on what it means, but here's what happened. So students immediately went to Lafayette's president to complain about it. The college chaplain, who is kind of amusingly also the head of the bias response team, the director of educational equity, and also the Title IX coordinator, called the student who held up the poster, told him that the phrase was hurtful and could be viewed as anti-Semitic. Then Lafayette's president emailed the campus community about the poster. The campus group that organized the protest said that we stand against and detest hate speech, and they're against anti-Semitism. Then the chaplain met with the poster-holding student again. The student agreed, told the chaplain, "I will not hold that poster in future protests." And so you would think, all right, mission accomplished. We've gone through this, everybody's reacted, if anything, maybe a little heavy-handedly for somebody holding up a sign. Unfortunately, OCR said that wasn't enough. They said that what Lafayette and what Michigan and what all of the sort of following colleges were expected to do was every single time there was an allegation of something that could contribute to a hostile environment, the colleges were now required to evaluate whether or not that had created a hostile environment sort of unmoored from necessarily being aimed at a specific person or group of people. And this is why that's important, because what it does is it means that you can have a free-floating hostile environment where instead of the hostile environment, which traditionally has been, is this student, like in Davis, it was a student named LaShonda Davis who was being exposed to some really pretty foul behavior for a fifth grader, frankly, and it created a hostile environment for her personally. The question OCR was trying to evaluate was, is this a hostile environment for Jewish students or Islamic students more generally? So you could even come late to the hostile environment. In other words, the environment could span the summer, we learned from it. So you could have, if you were a freshman who was coming in the fall, the hostile environment could partially be caused by things that happened in the spring before you got there. It also meant that if you were a freshman holding up your sign in the fall, you could be contributing to a hostile environment that was started by the people who left before the summer was over. And so we have this key to sort of regulating generally sort of like the vibes of a particular campus and giving OCR the power to regulate that in a way that it suggests that the only way to deal with it is to actually clamp down on protected speech, and that sort of comes out of the illustrations that OCR gave in so many of those. So that was a big concern. I think a sort of the highlight of what I wanted to point out from the Title VI jurisprudence, and happy to answer questions on that later. Then finally, and I'm sure we're going to be hearing a ton more on this. Oh yeah, sorry. Forgot I made a fancy one. Okay, I usually don't do that. Oh yeah, they always love to have a Trump tweet there. So March 2025, you started to get Trump's multi-pronged attack on all things college, and even though most of the things that the Biden Department of Education did, Trump purposely did the opposite, and vice versa. The cumulative theory of harassment was not one of those. Even though they're no longer using quite the same terminology, the effect has been the same. This is one of those areas where there's been some bipartisan agreement, which personally I could do without in this particular case. Obviously, we had the research funding cuts and freezes that I know we're going to hear more about. We've already heard a bunch about. Threats to accreditation. This kind of went under the radar, but they actually made a pretty good run at Columbia University's accreditation. The Department of Education informed the Middle States Commission on Higher Education that Columbia was in violation of Title VI, and Middle States put Columbia on warning status. They made it clear that they had not been de-accredited, but they were in fact, going to go forward with an investigation. Which, I mean, that'd be a pretty big deal if you de-accredit Columbia University. Of course, the deportation of pro-Hamas foreign students, and I put that in quotes not because I'm judging, but because that was, the idea is these people must be pro-Hamas. That included Rumeyya Ozturk, whose big offense was co-signing onto an op-ed in the Tufts Daily that wasn't even all that, hostile to anybody, and then freezing the student visas and suspending the participation. At one point, they actually revoked Harvard's ability to have all foreign students. That lasted a day until a judge shot it down, and that's still being litigated. But at one point, 1,800 individual students at about 260 schools across the country had been informed they had lost their student visas or they'd been terminated. Now, on April 25th, those were all restored, but again, you can see the kind of interorum effect that has. If you think that you step out of line, you might lose your student visa. How anxious are you going to be to speak out on college campuses? And one thing that I think is worth mentioning is how anxious, if you're an American student, as most people here are, obviously, how anxious would you be to hold an event where you might be exposing your roommate or your friend or whoever who's from Canada or Britain or Saudi Arabia or China, wherever it might be, to being deported if you basically say, go team to what it is you're saying. So if you're saying, I think the Israelis have gone too far in Gaza, and they say, yeah, I agree, they can be deported, are you going to say that? And I think there hasn't been enough consideration of whether or not of the effects of that. So anyway, I will move on. Thank you, and happy to take questions after.
Well, good afternoon. Get comfortable. But unlike my property students who are probably thinking right now, oh boy, Ellis is settling in, I will start a timer so I make sure I try to stay close to my 20 minutes. So it's a pleasure to be here today, and I want to thank the Law Journal and in inviting me, and in case it wasn't mentioned this morning, I am admittedly a last-minute addition to the panel because our prior panelist had a medical issue that prevented him from being here. And so in some ways, I realize that I am a little bit of a odd duck here, and in some ways, though, I think I am a bridge between this session and the morning session and Professor Adamson's keynote, in as much as I want to tell an account that is rooted in concerns around what the work that universities do by thinking specifically about critical race theory as a literature within law schools, and how that has been transformed into a piece of the sort of anti-DEI conversations that we saw this morning via Professor Adamson's keynote about the federal executive orders that sort of bring us into, the topic of this panel around higher education and curriculum, and in essence, bringing the claim forward that CRT through these methods is directly under attack, specifically as a piece of the curriculum of law schools and its sort of related study of history and culture and society through a avowedly race-conscious lens, which, by the way, is not CRT. And so to make that distinction very clear, which is part of what I will do in my time, but that this is, as Professor Adamson suggested, a content-based restriction, right? This is a direct attack on a direct piece of a curriculum, and places like Case Western Reserve University and the law schools that are represented here today all teach in some way, shape, or form, or not, but it's their choice to do so or not, and it is the choice of the scholars to produce knowledge of that sort or not. But to have the federal government impliedly dictate knowledge that is forbidden versus knowledge that is accepted, and to announce quite loudly, as happened in the Dear Colleague letter of February 14th, that certain knowledge is specifically disfavored, raises deep concerns about both the state of universities, the state of higher education, and as you heard from the introduction, my day job as a scholar is a scholar of the law of democracy from a critical theory lens. It raises concerns about democracy and ultimately makes us have to wonder whether these claims about being a democracy with its essential ingredient of free discourse, right? The First Amendment is the First Amendment that was ratified, not the First Amendment that was proposed, but it was the First Amendment that was ratified, and is important because freedom of thought is the thing that enables us the freedom to vote and to assess how our representatives represent us. Now, one quick qualification that I want to make clearly, because I also now sit on the administrative floor rather than the faculty floor, my comments do not speak for Case Western Reserve University, the School of Law, or the Office of Enrichment and Engagement. And in fact, saying that leads me to a particular first thought, right? I can have two hats. I can play multiple roles. And part of the challenge of education, put broadly, is to create minds that are able to hold different thoughts at the same time, and then being able to pick and choose what thoughts are necessary and proper for our own lives that we get to choose to live in the ways that we wish to live. And if that is the case, then, if that is in a sense the heart of freedom, then to impliedly or even directly suggest that certain forms of knowledge are, quote, divisive, discriminatory, stereotyping, stigmatizing, on the basis of mere assertion, rather than inquiry into the kind of knowledge and the articulation of specific facts in particular circumstances, which we heard my colleague just talk about. We want to know exactly what happened and why. But to just simply assert certain ideologies are disfavored by this government seems to cut against what the government claims we ought to be out to do. So a few thoughts. One, as you can tell from the tenor of my, commentary here, I believe that this is ultimately an ideological project, right? As we heard in the morning panel, that describing things as a racial project is an important act of naming, and that we can then critically examine how that naming, and it can be racial, it can be subordinationist in the sense of one's abilities or the type of content, but also the kind of power that the state wishes to assert, right? So maybe this is an identity project, a racial project specifically, and even a project in terms of defining state power. And it's seen through that lens, the concern about deciding what thoughts are appropriate and what thoughts aren't appropriate signals, at least for me, a disturbing trend, right? That we might be seeing a governance that is at least implying, without wishing to look like that it's implying, that the disturbing nature of sanctioned thought and privileged people who get a heightened status in society as opposed to others is actually beneficial to a certain conception of the state. And that this should be accepted by silencing those who would say that what I just named is what's happening, and that it ought to be known as a divisive act through the act of calling the thing that is a critic of the state divisive. Or in other words, by accusing critical race theory and race-conscious thinking and over-expanding Supreme Court precedent and arguably exceeding the scope of executive power, there is a political movement that wishes to assert power by blaming the powerless for attempting to overtake American values. And by doing so, redefining American values in the inherently contested space, if there was ever one, as something that benefits a certain group, indeed may benefit a certain kind of majority, but then masks what Lani Guinier called the tyranny of the majority that is imposing these thought restrictions. So I want to move through this to make a couple of observations. One, I want to talk about what critical race theory is and is not. Two, I want to talk about an important theoretical intervention briefly in terms of colorblindness and post-racial theory, which sort of undergirds both what we do here in law schools, but at the same time gives us an insight as to the intellectual grounding of some of this controversy that I want to lead to. And through that lens, I want to briefly do a reprise of what we heard during the keynote in terms of the executive orders, but reading them as coded censorship of critical race theory. And then I'll end with a few thoughts on the consequences of this. So what is critical race theory? Briefly, and I want to work through that phrase backwards. So when we think theory in an academic sense, because as I said, we're talking about academic literature here, right? A theory is a system of ideas intended to explain something, especially a system based on general principles independent of the thing to be explained, right? A theory takes an observational perspective and runs through assumptions about the thing it's observing. So critical race theory, well, if we talk about race, I think most people in society would agree that race is a social construct based on the idea that humans can be identified and categorized into groups based on physical characteristics such as skin color, eye shape, etc. Most of us agree that this is an idea, even though we realize that the rhetoric of race being real, salient, important, and deserving of social hierarchy is an idea held by others, right? And in that sense, there is discriminatory race projects out there. The idea feeds this, despite the fact that we can say to ourselves it has no basis in biological fact, but we can perceive as an ideological project that there are groups that ought to have power and ought not to have power. And I think a democracy, however, can't exist when we accept that premise, because then it becomes something else, right? If there is a favored group and a disfavored group because of race, it becomes something else. The tension between the salience of that idea and how it exists and moves through the world and what effects that it has can be thought of as racism. And in a way, we're using racism as a lens to understand power dynamics and competition, right? The belief creates prejudice, and the effects of that prejudice can be overt or covert, but have consequences. And understanding the nature of those consequences is the critical part, right? The analysis that seeks to confront those ideological, social, historical consequences and what they mean and how they have impacts, especially when it is hidden and coded. That is what the critical race theory school of research is out to illustrate. In the words of Richard Delgado and Gene Stefanik, right? The critical race movement is a collection of activists and scholars engaged in studying and transforming the relationship among race, racism, and power. So, if we read through that lens, then the movements that we have been talking about today and the exercise of executive power that has been the focus of our study then becomes trying to understand how power is excising certain forms of thought to serve its own purposes. So to explore that, let's take into account one of many things that I could point out in this theory, but I only have 8 minutes left. So I will pick on one sort of concept near and dear to the heart of how the law thinks about racism, which is colorblindness, right? The notion that we should and ought to live in a society where the law treats everyone equal, right? We pick this up from John Marshall Harlan's Dissent in Plessy. Our Constitution is colorblind and ought to know no discrimination, and everyone should be treated as such. Now, whenever I get to talk about Justice Harlan and our Constitution is colorblind, I feel the need to read the entire paragraph where that sentence is drawn from. So let me just read. The paragraph starts, "The white race deems itself to be the dominant race in this country, and so it is in prestige and achievement and education and wealth and in power. So I doubt not that it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in the view of the Constitution, in the eyes of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among its citizens. In respect of civil rights, all citizens are equal before the law." In one paragraph, we see both our Constitution is colorblind, all citizens are equal before the law, and the white supremacist racial project. So if anything else, stop and think to yourself, well, wait, these two different ideas exist in the same place. And notice we have spent over a century, and this ideology has motivated conservatives, liberals, and everyone in between, but we have picked and chosen what it ought to mean. Its latest iteration, I have argued in research, drawing on Professor Sumi Cho's work, is post-racialism, right? That racism is over. Hey, we elected Obama. Hey, we have moved on to something new and different, and therefore we need not talk about it anymore. And talking about a race actually becomes damaging and dangerous and stigmatizing and divisive, right? And mind you, the thrust of my remarks, which I will get to us in a second, is to speak specifically to the moment of this administration and what its Dear Colleague letter means in regards to that. But actually, let me start by focusing on the so-called left, right? The left embraces post-racialism in the form of, well, we have overcome. We can move on to talking about other things because we have the Civil Rights Act, the Voting Rights Act, we have Title VI, we have all of these things. And those things show that we are a formally equal society, and therefore we can have conversations about other stuff. But when I wrote this article before the Trump era, the right was sick and tired of being beaten up about being accused of being the racist. And it wanted the end to this debate and this discussion. And so we have this agreement about moving on. And yet we see the era of Trump. And as a law of politics scholar, I can't help but think about how the Trump presidential campaign started with what I have called in other work, racially coded messages, right? And I've written a whole essay about the racial coding in terms of the 2020 election, where illegal voters and bad election administration was directly targeted at cities that were of majority people of color. But then the Trump administration, and deeply criticizing, in basically every election, whether he won or he lost and then he won again, the sort of notions of voter fraud that I argue are racially coded, even in elections that he's won. But Trump too comes in. And of course, we get the Dear Colleague letter. But that also has to be read in the context of the executive orders that targeted the alleged teaching of CRT in K-12 education. But as I said earlier, simply teaching history is not critical race theory, because critical race theory does a specific job of criticizing structures and structural racism and not simply reporting the facts of things like slavery existed and Jim Crow existed, and that you need this basic knowledge to understand why equality is valuable today. But if we go straight to the Dear Colleague letter, it is a message written to universities to stop indoctrinating with divisive ideology and to stop specifically speaking in race-conscious terms, right? It, quote, says, a false premise that the United States is built upon systemic and structural racism, directly cutting at what CRT is about. It speaks in DEI, but that spills into intellectual traditions that would endorse DEI, right? And like I said, this language of discriminatory stereotyping and stigmatizing is the government in and of itself picking content to target. Now, this is despite its justification in SFFA versus Harvard College, which in and of itself has no textual justification for such an expansive interpretation. It only speaks to race-conscious tools used in the admissions process, and no more, and indeed creates carve-outs for military academies who are seen, and the court knew would be perceived as having a different kind of relationship with the public given the mission of the military. And there are other things that we could say about statute, and I refer you back to my colleagues' comments about the First and Fifth Amendment, except to say at the end of my time that this is ultimately, I would argue, trading on a myth that talking about the legacy and history of racism in a critical way, whether it's via professional critical race theorists or simply reciting the history in things like the 1619 Project, or the supposed threat that has been addressed on state and local levels in school districts of CRT, that trading on this is ultimately a project designed to create a diversity of thought that is not diverse. And it allows for a tyranny of the majority and accepted forms of thought that make those in power comfortable to be what ought to be the norm, and those who are not comfortable are disfavored. And so in this sort of amplified post-racialism that seeks to not only erase race, but to persecute those who might say those words, we have a danger. And I wrote a whole thing that I could go on in further detail about, but let me leave you with this thought that ultimately there is a problem with academic freedom in as much as this trades on the mismatch of intellectual diversity as measured by those who create knowledge with intellectual diversity as a form of diversity with which the majority is comfortable with. And the majority using its power to pursue its comfort does damage to the institutions that produce knowledge, innovation, and transformations that economically, politically, and socially, and I'll say this with all due irony, made America great. Thank you.
So I'm going to break the norm by standing for a few reasons. One, it's after lunch, and if I don't stand, I might keel over myself. I really appreciate the opportunity to talk here. I love this campus. It's so beautiful, and I've had many terrific experiences here. This has been a really generative symposium, and I really appreciate being on the panel with these folks and the folks who were here this morning. I will say, as a graduate of the University of North Carolina who teaches at the University of Michigan, the fact that you put me on a panel with two Duke graduates and an Ohio State graduate, but I guess it does suggest that the person who was here this morning who complained about a lack of diversity on the panels didn't entirely know what he was talking about. Maybe should have waited around. In any event, so our panel is about federal authority and the First Amendment in higher education, and I have a lot of things that I could say about the First Amendment in higher education. I'm going to talk about the federal authority side and maybe pick up a little bit on some of what Robert was talking about, drill down a little bit, because one of the most significant tools that this administration has used in its attack on knowledge-generating institutions, and in particular academic institutions, and I would argue not just their academic freedom, but their speech, has been the funding cutoff remedy under the civil rights laws, particularly Title VI of the Civil Rights Act of 1964 and Title IX of the Education Amendments of 1972. And what I want to say, as a person who grew up as a civil rights lawyer, started my career at the Civil Rights Division of DOJ, had the opportunity to return there as a political appointee under President Obama, is that the funding termination remedy we have seen is misguided and ought to be eliminated. And, you know, I think I now hear many of my friends in the civil rights community saying, what the bleep are you doing, Bag and Stas? So hear me out, because I think it actually makes sense. And sometimes I just provoke. That's not what I take this as. I really think all of those of us, and I spend a lot of my time working with folks in academic institutions and elsewhere who are fighting against these attacks on their academic freedom and these attacks on their ability to generate knowledge. All of us who are involved in those fights have an obligation to be thinking about what happens in the future and how we reform our institutions in the future, and this is a reform that I think is important. So let me just start with just orienting what I mean by the funding termination sanction. The major civil rights statutes that apply on campus take the form of federal funding conditions. Title VI of the Civil Rights Act of '64 is the model. The idea is if you are engaged in a program or activity that receives federal financial assistance, you agree that you're not going to discriminate on the basis of race, etc. And the idea behind that, there's a very often quoted line from Senator Hubert Humphrey, the principal supporter of the Civil Rights Act in the Senate, who said, look, simple justice requires that public funds to which all taxpayers of all races contribute not be spent in any fashion which encourages, entrenches, subsidizes, or results in racial discrimination. So the idea is, look, we're all paying for this, and so you can't be excluding people from the benefits of it. Simple justice. And so these laws, they apply only to programs or activities that receive federal financial assistance. Title VI was the original one. Title IX, which is sex discrimination educational programs, explicitly follows the same model. Section 504 of the Rehabilitation Act of 1973 prohibits disability discrimination, follows the same model. Section 1557 of the Affordable Care Act prohibits health care discrimination, similarly follows the same model. It applies to federal programs or activities with federal financial assistance. And the primary remedy set forth in these statutes, indeed the only explicit remedy set forth in these statutes, is termination of funding. And so Section 602 of the Civil Rights Act says compliance with any requirement adopted pursuant to this section may be affected, one, by the termination of a refusal to grant or continue assistance under a program or activity, or two, by any other means authorized by law. So the only explicit remedy is funding termination. It's very common to talk about the funding termination remedy as if it gives the federal government enormous power. And in particular, and I'm sure Robert, when he was criticizing Title IX as it was interpreted by the Obama administration, was saying this, because most of the critics of the Obama administration's Title IX interpretations, by the way, that wasn't my part of civil rights then. So, you know, I've written about this and defended some of what the Obama administration did and criticized others of what the Obama administration did on this. But, you know, the critics of the Obama administration's very significant moves under Title IX said, look, most institutions can't go without their federal funding. And so that means they are going to knuckle under even to overexpansive interpretations made by administrators of these federal funding connected statutes because they're afraid they'll lose the money. Yes, perhaps as a formal matter, they could go to court and challenge it, but they won't, because the risk that they lose their funds is so great. This sword of Damocles is so sharp and heavy over their heads that they're not going to challenge it. They're just going to knuckle under. And that was essentially the critique of various things that the Obama administration did under Title IX. Again, the critique took two forms. One was the Obama administration was overreading Title IX. I think an arguable point, but certainly a fair one. The other was that the Obama administration's actions were not just unlawful in the sense that they went beyond what Title IX required, but they were lawless because they were calculated to avoid judicial review by threatening such great sanctions. And I will say that second point is something I've also written a fair amount about, and I just have always said that doesn't make any sense, because at least until the last 8 months, the fund termination sanction has hardly been a powerful in terrorem tool. In fact, it's barely been used at all. So The leading study of Title VI in 1995 wrote that the termination of federal funds is a most difficult and awkward sanction to invoke and had been used at that point, 30 years ago, in no more than a handful of cases in the previous 2 decades. And this author said there is little prospect of seeing a substantially different record anytime soon. Well, that was true. We're 30 years later, so that's not soon as of 1995. But the crucial thing is it was only very briefly that the funding termination sanction was used at all, just for a couple of years during Lyndon Baines Johnson's administration in the immediate aftermath of the adoption of Title VI in school districts that more than a decade after Brown v. Board persistently refused to segregate. And even there, as I've written in earlier work, OCR very quickly reversed its funding terminations in nearly every case. And Title VI race discrimination represented the high point of the funding termination sanction under these statutes. So with only one very minor exception, the federal government has never cut off funds for a violation of Title IX. The federal government has never cut off funds for a violation of Section 504 of the Rehabilitation Act. And the federal government has never cut off funds for a violation of Section 1557, at least until Trump 47, the second Trump administration. There are a few reasons why, far from having significant bite, the fund termination sanction has barely been even a nibble. Number one is that Congress imposed a lot of very significant restrictions on the funding termination sanction. Some of these are procedural. So there has to be an express finding on the record after opportunity for hearing of a failure to comply with the statute. That's statutory language from Section 602 of Title VI that I was just reading. Also, and there's a lot of confusion about this point, the statute says that any funding termination cannot extend to the entire entity that has been found on the record after a hearing to violate Title VI or Title IX or 504. Instead, the funding termination shall be limited to the particular political entity or part thereof or other recipient as to whom such a finding has been made, and shall be limited in its effect to the particular program or part thereof in which such noncompliance has been so found. Now, a lot of people, in fact, a lot of people who should really know better, think that that provision was eliminated by the Civil Rights Restoration Act of 1987, which which defined program or activity to include all of the operations of an entity that receives federal financial assistance in any part of its operations. But that is not right. What the Civil Rights Restoration Act did is it extended institution-wide coverage, saying if you accept $1 of federal funds, your entire institution must not discriminate on the basis of race. But it continued to limit the funding termination remedy to the particular part of the program that was found to violate the statute. And it's not just that they left the language in the statute and they somehow forgot to take it out. In fact, if you read the legislative history, you can see that this was an intentional decision. Page 20 of the Senate report of the Civil Rights Restoration Act says the bill, quote, will leave in effect the enforcement structure common to each of these statutes. The section in each statute states that the termination of assistance shall be limited to the particular program or part thereof in which such noncompliance has been so found. The bill ... leaves intact the or part thereof pinpointing language. And the Senate report specifically endorsed what it called the seminal ruling, and I hate metaphorical language in that one in particular, the seminal ruling of the Fifth Circuit in a case called Taylor County, and it said, under the Taylor ruling, federal funds earmarked for a specific purpose would not be terminated unless discrimination was found in the use of those funds or the use of those funds was infected with discrimination elsewhere in the operation of the recipient. So you have to find a direct connection between discrimination that you found and the funds that you're taking away. What the Civil Rights Restoration Act said is the substantive obligations apply institution-wide, but an injunctive relief for violation of the statute could extend across the institution, but fund termination has to be limited to the particular part of the program where the violation was found. That, and I could, cite more about that, but when you read the paper, you'll see. But that also makes it very difficult to use funding termination as a sort of Damocles that's going to chop off the head of a violator. Also, the statute says that funding termination can't be taken until the department or agency concerned has given notice to the violator and given them an opportunity to comply and determine that compliance can't be secured by voluntary means. So there's an exhaustion requirement, and funding termination can't occur until 30 days after a report is filed with Congress, basically to give the members of Congress in the district where the funding's being cut off because the members of Congress care about pork going to their district an opportunity to go to the secretary of the White House and say, you can't bleep and do this because it's going to be very devastating. And there's an express provision in the statute for judicial review. So there's lots of procedural reasons in the statute why. It's just the juice is not worth the squeeze for an agency to try to take away federal funds from a violator of these statutes. And there are lots of reasons why they wouldn't want to anyway. If you think about who's taking away federal funds, it's the Department of Education taking away educational funds from universities, the Department of Health and Human Services taking away research funds from researchers at universities. Well, if they care about the public purpose of the funding program, if they care about financing people's education, financing medical research, they're not going to want to cut that off because somebody discriminated. I mean, that would be injuring innocent people instead of going after the violators. And Senator Humphrey himself, in the debates over Title VI, said this. He said, the remedy is a last resort to be used only if all else fails. And why is that? Because cutoffs of federal funds would defeat important objectives of federal legislation without commensurate gains in eliminating racial discrimination or segregation. But it's even worse than that, because courts, and I won't go through this now just for time reasons, but again, read the paper. Courts have used the fact that there is a funding termination remedy for Title VI and Title IX and Section 504 and Section 1557 to dramatically limit the ability of private parties who are injured by discrimination, victims of discrimination themselves, to bring their own lawsuits to effectuate the requirements of those statutes. So we have a funding termination remedy set forth in the statute that is not, in fact, the sword of Damocles. It is significantly limited by statute. There are lots of reasons why a conscientious administrator would not want to use it, and nonetheless, it has been used, its existence, its formal existence, has been used by courts to justify dramatically reducing the private right of action to enforce those statutes by the victims of discrimination themselves. Now, some civil rights advocates in the past have said, look, the problem here is that enforcers of civil rights in the government just haven't had the courage of their convictions. They haven't had the gumption. They should be cutting off funds more often. They should go through these very complicated procedural requirements, because that will send an important deterrent message. And people in the civil rights community have said that at various times. And my former student and now law school colleague, she teaches at Georgetown, Eloise Pasikoff, has written a terrific article making this argument. I will say the last few months demonstrates that call would be a mistake. The Trump administration, for the first time, has used the funding cutoff tool in a very significant way, and it's done so extremely aggressively, not to enforce civil rights, but to target political opponents, cutting off $400 million from Columbia until they agreed to a set of demands that went well beyond any plausible violation and that intruded on their academic autonomy and academic freedom in significant ways. Cutting off $2.7 billion from Harvard as leverage to make even more extensive demands, which provoked Harvard to file a lawsuit. As of now, Harvard has prevailed in the district court, but we know what happens to district court decisions against the Trump administration these days. Cutting off $1 billion from Cornell, $790 million from Northwestern, over $500 million each from UCLA and Brown, and a mere $175 million from Penn, on the basis of, again, allegations that would not be sufficient to establish a violation of the underlying civil rights statutes under accepted standards. Some of these institutions have decided to give in, Brown and Penn. Others are continuing to negotiate and may litigate. I think about UCLA, Northwestern, Cornell in that category. The Trump administration has used the threat of funding cutoffs to make threats against UVA, forcing them to depose their president, and against George Mason University, which has stood strong. But this is continuing. Notably, these fund cutoffs and threatened fund cutoffs do not comply with the statute. They don't follow statutory procedures. Remember, there are all these procedures. The administration didn't go through any of them. They don't respond to plausible violations of the law. Happy to talk about that. And they don't at all comply with the pinpoint provision. They cut off all funds to Columbia or to Harvard or to these other institutions on the basis of alleged violations that did not occur across the entire institution. These actions are pure bullying, and they're part of a pattern of attacks on independent civil society organizations, which is now being empowered by this tool. Now, a lot of my friends who are left of center activists would say something like, well, sure, Trump's using these powers in an abusive way, and it's just yet another example of how the Republicans are willing to use the tools they have, and the namby-pamby centrist liberals who occupy the power in the Democratic Party are not willing to do it. So let's take a page from the Trump playbook the next time we're in office, and let's use this. I am, in general, sympathetic to the position that Democrats, liberals, people to the left of liberals should not unilaterally disarm. But I don't think that argument works here. The abuses we've seen in the past few months aren't about Trump having the gumption that liberals didn't. They're about a fundamental problem with the funding termination mechanism. And that problem is that the fund termination mechanism ties effective enforcement of civil rights to important public purposes that are served by federal funding. If you care about the public purposes served by federal funding, you are necessarily going to be wary of taking away your effectuation of those purposes in order to serve civil rights. You are faced with an impossible choice if that is your remedy. What Trump shows is that the termination mechanism will effectively be available only when the people who are administering the civil rights enforcement edifice don't care about or are affirmatively hostile to the public purposes served by the spending programs, right? I mean, it's not a surprise that the same administration that is cutting off all funds to Harvard and to Columbia for medical research is also just dramatically cutting medical research funds, right? Those are ideologically aligned. Now, I have some suggestions, which if you read the paper about the solutions here, I think we can continue to tie the substantive requirements of these civil rights laws to the receipt of federal funds. I think that has certain value, both in terms of the normative value articulated by Hubert Humphrey back in 1964 and in terms of overcoming state sovereign immunity. But I don't think we need to have the funding termination remedy. In fact, I think the funding termination remedy on net is bad for the world, and we should get rid of it and replace it with an appropriately tailored set of individually focused remedies. And thank you very much. I look forward to your questions.
Right. Thank you all. I'm so thrilled to be on this panel with these amazing scholars. Thanks for putting me last. And I mean that, though, because I think my talk actually has some amazing connections with almost everything that we've heard so far today. So hopefully this is a nice way to draw some of the threads together. So This is the story of a pair of emails that I received in my role as a faculty member in February.
You close the mic.
Of course. I have a podcast, but I'm not good at it. So this is a pair of emails that I received as a faculty member in February of 2025. I started my career as a high school English teacher, so obviously I'm going to bring in Charles Dickens. So he opens his classic A Tale of Two Cities with the paradoxical line, "It was the best of times, it was the worst of times." So he's talking about a moment of contradictions when freedom and repression coexisted, when institutions were under siege yet struggled to endure. I want to borrow that framing, but maybe not on such grand terms, because this is, after all, just a tale of two emails. So our first email was in response to an executive order that we've already talked about, signed by Donald Trump in January of 2025. That order, which was the first of many of its kind, directed the federal government to take immediate steps to end federal implementation of, quote, unlawful and radical DEI ideology. The order itself didn't seek to define these terms, as we've talked about, nor did it go into detail about how to accomplish this goal. That, importantly, was left to others, like my institution. The second email addressed a notice from the National Institute of Health that indicated that NIH would be capping indirect costs at 15%. Now, for those of you who haven't felt the academic pressure to go out and get grant funding, indirect costs are things like facilities, equipment, administrative support, basically everything that you're not going to put as a line item on a particular grant, but that your institution spends money on to support the work. So to put this change into context, U.S. negotiated rate is 52.5%. I'm no mathematician, again, I was an English teacher. That feels higher than 15%. And when applied to the over $250 million in NIH grant funding that UF received in 2024, we're talking about a decent chunk of money, or at least a massive administrative burden to align the indirect rates with the new expectations. So my institution, faced with these executive actions, had to decide how to respond. Enter our two emails. This is the first email that I received from our Vice President for Research to the faculty on February 5th. It says that, quote, as a result of the executive order, we should immediately halt all grants or contracts that use or promote the use of DEIA principles and frameworks or that violate federal anti-discrimination laws. Now, this email is interesting for any number of reasons. I'd like to just highlight two. First, I find the use of the word "or" incredibly interesting. Because that "or" recognizes that there are DEI activities that are not a violation of federal civil rights law. And that's something that we've seen a lot of these orders do, and a lot of this stuff coming from the Trump administration, is they equate unlawful DEI with DEI practices. They use a lot of linguistic maneuvers to basically create those as synonyms. The second thing that I want to identify is just the phrasing of DEIA principles and frameworks. Now, we've already talked about kind of the ambiguity of language and the importance of words. For me in my work, and the way I understand my concept of justice, equality and equity is a major part of how I conceptualize justice. And all of my work as a school law scholar is about justice in some way or another. So does that mean that my work, as attenuated it is under DEIA principles? I also do a lot of special education work, which the A is accessibility, the I is inclusion, is my special education work, and the classes that I teach, does that fall under this as well? This email and the executive order do not answer those questions. Instead, that is now left up to me as the individual to figure out where those lines are. So 5 days after I got this email, I got another email. This one was slightly different. Rather than direct us to comply with the NIH rate changes, we were told to ignore them. We were told to take no action to make any changes because our administration expected legal challenges and hoped that NIH could be convinced to change their approach. 2 emails. Both reflect executive attempts to change the terms of already awarded grants. On their face, these actions are very similar. Yet, my institution's responses were vastly different. Strict and immediate compliance in one case, open resistance in the other. Like the London and Paris of A Tale of Two Cities, these emails reveal a potential paradox. Why did UF respond so differently to similar actions from the second Trump administration, and what implications does this have for the legal and practical limits of executive authority in higher education? As one of my law professors at the Ohio State University would say, you never know what the rules are until you know the rules about following the rules. To understand these rules about the rules, we need to attend to legal doctrine as well as the political economy of higher education. When I say political economy, I mean the broader system where politics, economics, and institutions interact. It's about how power, money, people, and rules shape each other. Law is a part of that, of course, but the key point is that universities don't just read the Constitution and act. They respond inside these larger systems, weighing legal risk alongside political pressure, financial stakes, and their educational values. This is the process by which the law is translated from words on a page into lived reality. So how should we understand the current political economy of higher education? Well, as we talked about, and as is kind of a theme of a lot of our talks today, these two emails are responses to pieces of a larger ideological assault on higher education by the Trump administration. Officials in the administration have openly described their goal as disrupting higher education and breaking what they see as liberal orthodoxy. The mechanisms and justifications of these efforts are wide-ranging. Many of these efforts have been justified as necessary to address anti-Semitism, to address impermissible racial discrimination through DEI programs, and remember back in the early days of the Trump administration, with DOGE, the efficient and accountable use of public funds. All of those have been used as shifting justifications for these larger actions. The mechanisms, though, to accomplish these goals, the administration has engaged in a full-court press of higher education. One strategy has been to stop the flow of money. The Trump administration has disrupted existing grants in the billions of dollars, halted payments, sought to terminate and not award new grants that don't align with the president's preferred viewpoints or policies. We at UF received a list, and I think this has been published elsewhere, of like the words not to use in new grant proposals, going back to what Professor Kolker was talking about with scraping stuff from the websites. And this has led to substantial financial uncertainty for colleges and universities and their faculty. Our tenure and promotion, in many ways, relies on the grants that we bring in and the work that we do with those. So, relatedly to all of this is the threats to stop federal funding, as we just heard about under Title VI and these other civil rights laws. And connected to that, the administration has leveraged existing rights enforcement to put pressure on institutions of higher education. So by May of 2025, the U.S. Department of Education's Office for Civil Rights had launched over 80 new investigations directed by the Trump administration, dealing with DEI-related discrimination, transgender student policies, and anti-Semitism. And these new investigations were opened despite OCR losing approximately 40% of its staff in massive layoffs at the Department of Education that saw 7 of the 12 OCR offices closed. So we have fewer staff and this wave of new investigations. Those investigations were never done quickly, but these were. So historically, the process of these investigations themselves has been the punishment because the enforcement mechanism was a gun too big to fire. So resolving these required extensive investigation time, resources to resolve. They almost always ended up in resolution agreements, but the Trump administration has shown a willingness to use these to threaten, and without following appropriate process, threaten the federal funding for these different institutions who have come under their scrutiny. Now there's other levers too, beyond just the money. The Trump administration has also used some novel mechanisms as well. It sought to use its authority over immigration to block colleges and universities from enrolling international students. and employing international faculty. The president has threatened schools' tax-exempt status with the IRS, which would have profound implications for tax burdens as well as their philanthropic support. If you can't donate money and write it off from your taxes, there goes one of the primary mechanisms that colleges and universities use to get philanthropic support. The administration has threatened to add new taxes to the university's endowments, has placed caps on some students' federal aid, and it's also sought to leverage accreditation as another potential fulcrum. In April, President Trump issued an executive order that instructed the Secretary of Education to focus greater scrutiny on higher education accreditors. These are the people that basically give stamp of approvals for colleges and universities to, assess kind of quality and that they're meeting certain academic standards. The order stated that these accreditors needed to focus on eliminating DEI and promoting, quote, intellectual diversity. The irony of those two things next to each other I don't think is addressed in the order. But going a step further, HHS and DOE have recently informed the accreditors of both Columbia and Harvard that they may no longer meet accreditation standards due to findings by the Trump administration that they are in violation of federal civil rights law. Decrediting Harvard and Columbia would be a pretty big deal. So rather than understanding or addressing these actions individually, these efforts all inform the political economy of what universities are navigating. Also relevant to these legal actions are the legal, political, financial, and educational risks that universities have to weigh as they chart a course through these uncertain waters. So in terms of legal risk, the question is beyond whether or not an action is lawful or not. These risks go beyond the merits. Universities have to consider the cost of legal action, the likelihood of legal action, how long it's going to last, how resource intensive it's going to be, what the political fallout is going to be, and ultimately the probability and significance of any potential finding against or for them. Further complicating these considerations, though, are questions about the current treatment of precedent and the ideological makeup of the courts. Thus, while universities have strong legal arguments to challenge many of these actions on spending clause, First Amendment, or procedural grounds, as demonstrated by Harvard's success at the district court level to unblock $2 billion worth of funding, the strengths of their arguments is only one part of one piece of their deliberation. Also weighing heavily on public education institutions are the politics at play here. And I think we're all probably very familiar with just how complicated the political situation has become. Public trust in higher education has been declining for decades, with growing partisan divides. Add to this a volatile and polarized political environment, and institutions aren't able to please everyone, sometimes playing it safe and staying out of the spotlight and off the agenda is the safest play. Financially, the risks are potentially catastrophic. Losing all of your federal funds would likely be a death blow to many colleges and universities. Balance this against the costs of settlement and the costs administratively and financially of prolonged litigation. Also of concern, though, are impacts of state funding and philanthropic support, depending on the politics of how all of this shakes out. Many of our state institutions rely heavily on state funds, and those states are, in many situations, ideologically different than perhaps the institutions they're funding. Finally, and from where I'm sitting as a former English teacher and a school law scholar, and most importantly, is the educational risks. The Supreme Court has recently repeatedly emphasized that colleges and universities serve the public and play a crucial role in the pursuit of truth and the preservation of democracy. And higher education institutions see themselves advancing those same missions. So this is a word cloud, because who doesn't love a good visual, of 300 college and university mottos. So I put them all into this word cloud, and these are the words that show up the most. 3 themes jumped out to me, and I'd love to hear what you think too. Seek truth, serve others, cultivate character. I think that covers a lot of what is on there. And these educational goals are at the forefront of institutional decision-making, and as institutions navigate this political environment and the various risks, they also consider the potential impact on their educational goals. So how has this political economy been playing out? How does it help us better understand the scope of executive authority over higher education? So we've talked about Harvard, Columbia, Brown, University of Pennsylvania. They provide some useful case studies. They've all found themselves at the scrutiny of the Trump administration. For Columbia, Brown, and Penn, they've all entered into agreements with the federal government to avoid, hopefully, additional scrutiny from the Trump administration. So Columbia entered into a $221 million agreement, Brown a $50 million agreement. Both of those included policy concessions related to the use of diversity statements in admission and hiring, transgender student policies, which was also the subject of Penn, which didn't have a dollar sign attached to it, and campus climate related to particularly the treatment of Jewish individuals on campus. Compare these responses, though, to Harvard and now UCLA, who have proactively brought lawsuits challenging the Trump administration's actions. So far, Harvard's been successful in challenging efforts to limit the enrollment of international students and freezing the $2 billion the $2 billion in grant funding. And similar situations are unfolding across the country now at least a dozen institutions who have been targeted by the Trump administration, including Princeton, Cornell, Northwestern, Duke, UCLA. And as each of these targeted universities navigate these assaults, they have to balance the legal, political, financial, and educational risks. And depending on their context, their mission, their tolerance for risk, and how they prioritize those values and risks, we've seen institutions charting very different paths forward. But what does this mean for colleges and universities that haven't been explicitly singled out, like my institution, the University of Florida? Our tale of two emails tells a very, very similar story as the one playing out at the institutional level. Within institutions, administrators are weighing the same considerations. Given the political context in Florida, we're probably about 2 years ahead of everyone else on the anti-DEI stuff. So I don't know if that's a good thing. I've got more experience, I guess. Responding in any other way to that first email was politically infeasible. There was just, or at least very risky. Given the political climate in Florida, there was no other way for the institution to respond. For the second email, the severe financial risks outweigh the slim possibility that this requirement would go into effect and would be implemented and enforced. So by exploring how institutions and administrators navigate the current political economy of higher education, we can understand and inform the varied responses to the Trump administration's efforts to remake higher education. These responses vary from what I call aversive hypercompliance, namely adopting risk-adverse interpretations to avoid legal scrutiny before you ever become under the microscope, like you have to do with our first email, to active resistance, like in the case of Harvard and their proactive lawsuits. Interestingly, a more subtle form of resistance that has grown out of this is that universities targeted by the Trump administration have nearly doubled their spending on lobbying this year, potentially trying to get ahead of some of those political risks. So integrating law and the political economy of higher education also demonstrates the limits of legal doctrine. Formal doctrine constrains the executive on paper, and perhaps after years of litigation by willing colleges and universities by the courts. But the political economy shapes the law's reach in practice. We know that these actions are having a chilling effect on institutions, their faculty, and their students. A recent report from FIRE found that over 1/3 of faculty had recently toned down their writing, and that a sizable number felt that they were unable to speak freely for the threat of punishment or other consequences. And emerging research is bearing this out, both in Florida and across the country. So through its efforts and the current political economy of higher education, the Trump administration is accomplishing indirectly what the First Amendment forbids directly. So returning to Charles Dickens, he wrote of Revolutionary Paris that, quote, "It was the age of wisdom, it was the age of foolishness, it was the season of light, it was the season of darkness. higher education stands at a similar crossroads. Our two emails crystallize this paradox. And to put it into Dickensian terms, is now the age of compliance, it was the age of resistance. So both of these emails were a response to actions that tested the limits of executive authority. And they reveal that these limits are mediated by legal doctrine, but more immediately by institutional discretion shaped by the political economy of higher education. Ultimately, the future of academic freedom won't be decided only in the courts. It will also be decided in inboxes, conference rooms, faculty meetings, classrooms, and on social media, in the everyday yet significant choices that institutions, faculty, and students make about whether and how to comply or resist. And that's our tale of two emails.
Thank you very much for the panel. I think we have, 10 minutes for questions?
I think until quarter after, or I guess we have wrap up. I don't know that there's much to say with wrap up, but.
Okay, so more than 10 minutes.
Yeah, let's say 15.
Okay.
One question. Oh, sure. One question is about, and I was struck by the earlier panel when Ruth Kolker talked about the immediacy with which Ohio State kind of scrubbed everything. Although I'm sympathetic with the views of the folks on this panel, I also thought there was virtue in having George Dent kind of mix it up. And so I want to ask a question that might mix it up a little bit to get your reaction. And that is, I wonder whether there there seems to me to be sort of this possibility that the reason all of the attacks are going to the types of exercise of power and the remedial impact of what the Trump administration has done, and I understand that, but I wonder why we haven't seen a full-throated defense of the following proposition, that the DEI initiatives and programs of the majority of colleges could in no way, upon scrutiny, be deemed to be violative of the non-discrimination norms which the Trump administration is purporting to enforce, although most of us recognize that that's a little bit facetious. But I wonder whether there's something there that we're not seeing. In other words, Ohio State didn't immediately re-articulate or point out why it was in the right. They immediately scrubbed it. And that, I'll tell you what it tells me as someone who focused more on litigation than on academic life for the last 20 years, is that what would I paint that as in court? I would paint that as an acknowledgement that they had screwed up in some way. And so I wonder, is there a way in which we've sort of screwed up, even with our best intentions in our DEI programs, in some way that we can either refashion them, strengthen them to make them more impervious to this kind of attack in the future? So I ask it again. It's a mix-it-up question, but not in hopes of seeing DEI dead, but in hopes that maybe it gets reborn in a way that's a little more sustainable and impervious to attack.
Okay, I'll go first. That's good. You'll have forgotten my answer by the time other people talk. So first of all, there have been full-throated defenses. I mean, in response to the Dear Colleague letter that took these sort of, to me, implausible positions about what the law required, a number of law professors around the country, including myself, wrote a very long memo to general counsels around the country saying, this is totally wrong, and in fact, standard DEI practices are not a violation of the law. But I take your point that it's the institutions, haven't defended it, and I think from my perspective, there are a few things going on there. One is this sort of fear and risk assessment, that we heard Chris talk about. Another is, look, there are constituencies within university governing boards that never wanted to do this, that felt like they were bullied into doing this, that felt like the George Floyd protests and even before then, the beginnings of the Black Lives Matter movement at the end of the Obama administration led to student pressure that they were caving into, but they never really liked it, and so they were looking for an opportunity to pull it back. I think there's also the fact that the way that some DEI programs were implemented, or some aspects of many DEI programs were implemented, while not plausibly unlawful in my view, were kind of not very useful, and were certainly perceived by people who had to undergo the programs as very annoying. And so there was not a lot of constituency for the programs. There was some, I mean, an important constituency and people very angry. At the University of Michigan, we weren't targeted in any way. Our university got rid of all its DEI programs too, right after the election. And they explained it as we're avoiding liability, we're keeping our heads down, we don't want to be on anybody's target list. But there have been a number of long articles in the New York Times about how everybody at the University of Michigan hates DEI. Well, it wasn't everybody, it was actually just the people who were complaining, but there were a lot of people who were complaining. And so I think it's complicated, but I like the way Chris tells the story in the sense of there are a lot of constituencies, and it's a very political process within the university as well, and that's certainly been my perception. But I don't think there may be people who believe that DEI programs are unlawful. Certainly that's the view of the Trump administration. I don't think a lot of the institutional leaders thought that. I just think they were either afraid or were looking for an opportunity to get rid of them.
I mean, I'll be more of a hatchet man on that. To suggest that our evaluation has been a lot of times what there is a mix of DEI programs that are clearly lawful, and I think it's ridiculous that giving people lists of words to take down, etc. I mean, that doesn't even all that is just putting a Band-Aid. If the problem is that the DEI stuff is there, just taking black people off of Case's website does not solve whatever the underlying problem of that was, right? So I think there's a mix of that, but there is also a lot of unlawful activity going on. Universities are big institutions. I think one of the most obvious places we see that is it's rare that you don't. There are plenty of faculty members who have stories about, particularly faculty searches, where there is effectively some sort of mandate that you are only allowed to have X number. So if you've got 4 people, 3 of them have to be underrepresented minorities, right? This is a form of racial preference that isn't legal unless it's being done as part of an effort to make up for specific incidents of past discrimination. But faculty members do not realize that. Like, the faculty members actually conducting the searches, that has not trickled down to them. And so this keeps happening, and you keep seeing these reports of this happen. And I suspect that a big part of the hammer that the Trump administration is using here is that they know that universities know that if somebody really looks hard into what they're doing, there's somebody on campus who is breaking the law in a way that is unambiguously unlawful. And that is a really good hammer to use on the rest of the program, because you can use it to smear the entire effort. And there's enough clues left over in like the settlements they make with people, particularly, that I think that's part of their strategy.
So I want to push back on the question in the sense that the question that you ask is a subset of a bigger question. Where is the full-throated defense of living in what is for America a very young multiracial democracy? So I think I come at this as, to pick up on what Sam said, right? There are some people who did not like having this to begin with. Some people who, in the leadership of higher education, who are calculating risk and reward, maybe some, senior university administrators and boards of trustees who felt backed into this, and some people who I would add to the list of possible characters there some people who might have taken advantage of the political situation, not only to sort of avoid the problem that they might see in the particular electorate, but who do not want to live in a multiracial democracy. Period. Full stop. Right. I alluded in my talk to most people agree that, to put it very simply, racism is bad, but most is not all. Right. And in some ways, we have political distortions that might let that minority have over exhaustive influence in society, who then might run the gamut of politics in order to create a space where certain people who also share those beliefs end up being in power and then using the mechanisms that we've just spent the last hour and a half talking about to go after things in this way. And so the deep premise is in need of defense. And mind you, maybe I pitched the next year's symposium right there, but there are dimensions to the claim that you're asking us to think about.
So, I'm stuck back on the question that has been sort of dogging me all day, which is what's changed. It's very obvious to me that something has changed, even in the last 2 years since we had a symposium on this. And yet each of you in a way reminded us that what has changed is not the fact that the government is involved in making decisions about what can happen on college campuses. It's the very existence of Title VI and Title IX are decisions by the government about what can happen on college campuses. And they are very clearly anti-discrimination measures with potentially severe consequences, although, Sam, I think you point out that those consequences are severe in ways I hadn't thought about before, so thank you for that. Is what's happening now only different because it's sort of anti-reverse discrimination, whatever that means? And I think the presence of what I find to be perhaps disingenuous, but nonetheless loud discussion of anti-Semitism to maybe confound that. So sort of, is this the same thing, and the only thing that's changed is that it's anti-discrimination rather than just anti-discrimination? I think the answer is no. I think something else has changed. As Chris points out, it's very easy to throw the minority under the bus, and maybe that's why it feels so different. But what's your take on what's changed?
I think Sam sort of intimated of this, and it's something that I think I didn't manage to get across, and it was in my presentation, which is that I believe it is a conscious political decision on behalf of the administration that they no longer have a constituency that is worth protecting in the colleges and universities. The way I've seen this, and this is not a classy way to put it, but they feel like the hostages are all dead, right? Like the higher ed is already like, what are they going to do? Get rid of the last conservative professor? They already did that 10 years ago. So there's no more constituency. That's how, now, whether or not that's true, and of course it's not, of course it's not true, technically speaking, but it's close enough to being true that, that's why you see this opening. I think that's a big part of why you see this gap in confidence opening up, where I think the Trump 40, because Trump 45 did not do this. Same person, right? Many of the same people didn't do it. Some calculation changed, where they decide that they no longer have a reason that they have to consider what damage they might do to higher ed. And yeah, you have to have, if they don't care, then you have a lot of freedom.
I would just say one other thing about that, which is I think you have to see what's going on with respect to anti-discrimination law enforcement at campuses in the context of a much broader set of actions that the Trump administration is taking, which are systematically deploying the power of the state in its most aggressive forms against either opponents of the administration or independent sources of power and authority. And so, look, we're talking during the week when Jimmy Kimmel was almost certainly fired. He's not been formally fired yet, but that seems to be pretty clearly where it's going. And the pretext was something he said about the person who shot Charlie Kirk, but then, Donald Trump gave away the ballgame saying, well, these people attack Trump all the time and they're not allowed to do that. Brendan Carr, the head of the FCC, had previously initiated investigations of many major news organizations for coverage that they believe to be unfair, the massive libel suits that are being brought against press organizations, but also the executive orders targeting law firms, are the same thing. The shutdown of federal funds to research, again, not when it's not explicitly tied to anti-discrimination, and on and on and on. I mean, there's just this whole set of actions that this administration has taken saying, if you are speaking in a way that we like, we'll continue to support you. And I noticed the head of the Ohio State University ran to Washington and said, we are going to be your friends on this, and that's the dynamic that they're trying to promote. But it's not, so I wouldn't. They're using tools that were used or were available to others in particular areas, but I think you have to look at the whole picture.
And now I'll add, at risk of the answer changing as it goes down the line, the coordinate branches of government have taken either little to no interventionary action, like Congress has remained all but silent in regards to a lot of these things, including power taken by the executive from Congress to redefine major statutes and other powers that were supposed to actually create tension, right? And that was the original constitutional design. And then a court that seems sometimes collaborative, sometimes sort of standing by, oftentimes willing to simply find justifications for things. I mean, I'm thinking back to Trump v. Anderson, and once we got this interpretation of Section 3 of the 14th Amendment, we see an imperial presidency becoming more and more imperial. So there is the context there as well.
Yeah, and so much of this, to me, raises questions about the rule of law and the relationship of what it is we all do in these spaces, right? And it seems like a lot of these shifts are moving away from a rule of law to a rule by law, rather than because many of these actions are taken independent of their underlying lawfulness. And so I think it's a number of factors: declining trust in higher education, the perception of higher education institutions as being too liberal, the anti-intellectualism. We saw that in the vice president debate when J.D. Vance kept talking about common sense. And I think all of these things are just kind of coming together to create a perfect storm that is flooding the zone.
One last quick.
Yeah, just something I've been thinking about this whole time is I'd imagine if we had someone from Bob Jones University circa 40 years ago here, and I want to be clear, there's no love lost between me and Bob Jones University, right? But very famously, they had a policy that students couldn't be engaged in interracial dating or marriage, and their tax-exempt status was taken away by the IRS, and this was upheld by an 8-1 Supreme Court. And I'd imagine if we had someone from Bob Jones circa 40 years ago here, he would say that, hey, the government came after our free speech, they came after our sincere religious beliefs. Again, not my sincere religious beliefs, but they're admittedly, I think you'd have to assume sincere religious beliefs. And we can distinguish this conversation maybe on procedural grounds, Professor Beghetso, sorry, I'm pronouncing your name, where I pointed out that there's procedural things the Trump administration's doing. Maybe the IRS followed the right procedural things there. But on like purely First Amendment grounds, are there ways to distinguish this from what happened to Bob Jones? You know, I don't know. I don't like racial discrimination, right? I don't like bans on interracial marriage or whatever like that. But it seems conceptually similar.
Yeah, they would certainly argue that it is conceptually similar. I mean, it is conceptually similar. Are there ways to distinguish them First Amendment wise? Sure, like there are. But if you were to bring them forward, they would be saying, "I told you so," and that this is what we were warning about. This is what happens with the government. I mean, I have my moments of sheer libertarianism where it's kind of like, well, this is what happens when the government gets too intertwined in everything, and there is some real merit to that.
I mean, all I can say is this was sort of the point that I was trying to get people to answer in the question I asked in the first session, which is, you know, we are going to live in a world where, I mean, this is Charles Reich, the new property. It's not like a new point. We are going to live in a world where the government is financing lots of really important stuff we all do, and our personal and institutional livelihoods depend on it. And that's going to give the public a claim on things we do, but we also need to protect liberty. And where that line is actually a really complicated question. I am quite certain that if Bob Jones came before the Supreme Court today, it, you know, as res nova, as opposed to, you know, being on the books and stare decisis, that it would come out the opposite way. I mean, and honestly, all the people within the Reagan administration who flipped sides in that case, you know, like John Roberts was there at the time, and you know, that's the folks who Sam Alito was hanging out with, and those were folks who were significantly to the left of, you know, some of the Trump folks coming on now. So, but you know, I think you can say no race discrimination ever. That's a nice way to distinguish it. On the other hand, I don't think that would satisfy the folks at Bob Jones University.
I'm going to quickly refer you back to my prior answer. Some people don't like to live in a multiracial democracy. And I'll also point out that in some ways, I get the First Amendment framing, but at the same time, the Constitution didn't stop with the Bill of Rights, right? And so there is a 14th Amendment, a 15th Amendment that raise complicated questions, amendments designed to promote multiracial democracy. And so if those people came here today, my question back to them would be, how would you accommodate that, especially if it were like a textualist or originalist kind of conversation we would have?
Yeah, I have the benefit of having my slides up. You know, for me, like, I always go back to what is it we're doing as institutions of higher education, right? Like, we're serving the public. And so the extent we can go back to those kind of public service goals and align our actions and, you know, the lines we have to draw about state authority and what we do, and the more we can do to kind of articulate how our actions align with those goals, I think, like, maybe that gives us hopefully a useful framework to think through, you know, how to navigate these complicated issues in different contexts.
Right. I want to thank the panel one more time for the fascinating conversation. Are there closing remarks, like it says on the agenda?
Would you like to mark?
I can make a couple of closing remarks. Very briefly. So the main closing remarks I want to make are thank you so much to the panelists, to Maggie, to Fatima, who is ill today, but I was watching online, I hear, to all the faculty members who could make it, to everyone who's watching online. This was a great event, and I think a thought-provoking one. I hope we can all go home and keep thinking about these questions. I look forward to publishing about them. And if the speakers who are still here could gather for a photo, there aren't very many of you left, but it would be really great to get a photo of at least a few of you. And have a great evening, all. Thank you.